is there, look at his secret group, look at this, why is he liking her post all the time, why is she chatting with him here, and look at the Twitter post, and look at him hashtagging her all the time. I mean, for those of you who are from familiar with these internet terms, you recognize what I'm saying, because these are problems. Your wife or your husband catches you cheating on Facebook and then produces it in court as proof of cheating. Well, is it proof really? What is the law on this? So the law on this is complex. The TLDR version, too long, didn't read, I'm going to give it to you in short version of this sort of anomaly, is 65B Evidence Act. Briefly put, 65B Evidence Act is a special provision that deals with electronic evidence. If you want to walk into a court and show a printout of a Facebook post, or you want to show a CD that you've made, frequently wives or husbands will hire private investigators who will tail their spouse and pick up damaging evidence, including videos and audio and other things, and locations and photographs, and then produce them in court and then say, right, look at this is real evidence. And then they will say the Family Courts Act, which establishes family courts, under which the administration of justice in a family court is governed. This act, under section 14, says that the laws of evidence in family proceedings, in matrimonial proceedings under this act, are not strict. This court is allowed to allow otherwise inadmissible evidence in making its judgment. That means if I produce this Facebook photo or this CD drive or recording of my spouse in a dalliance with some paramour, then this CD could be admissible in court. But is it actually admissible in court? Because then you're hit by 65B Evidence Act, which says, where is the original device? Have you produced the original device? If you haven't, is there a competent certificate? Do you have a proper certificate that certifies? Now, who is to certify? Well, if it's a Facebook post, then interestingly, Facebook has to certify that this is in fact an account that belongs to this lady or this person who is your spouse, and that this post was made on this day, at this particular time, on this particular occasion. And furthermore, that the records are maintained by Facebook on these servers at this location and have not been tampered with. But is some representative from Facebook going to appear in your matrimonial trial and say this? Can you get one? Will the court issue a summons to Facebook to come and appear before it and say that the records have not been hacked or otherwise tampered with? It's up to you. It's luck. How much money can you pay really? How good is your lawyer? How lenient is the judge? How much of the Evidence Act does the judge really understand or care about? This is an issue. This is a procedural issue. And going forward, this is going to become a bigger issue, because every day I walk into a court, every time I go for a matrimonial matter, I see somebody bandying about a WhatsApp text or Facebook. And it's going to become a problem, because if it is deemed not admissible evidence, then you may as well toss it out and continue to reside with your adulterous spouse. If you want a divorce, well, get a 65B certificate, potentially. Now, the reason I'm highlighting both issues with substantial law, like 498A, a section that creates an offence, and procedural law, Evidence Act, how to prove an offence has occurred, is because you have to look at the solution from a holistic perspective. It has to be not only the removal of human bias, which is the judges, but also systemic institutional bias in the form of procedures. Today, as a result of the 2015 judgment of the High Court in Kusum Sharma's case, as a result of this judgment, today every matrimonial divorce petition that is filed, even a 125 CRPC petition which is filed, requires an affidavit of income. The petitioner, the applicant must clearly, it's quite an exhaustive, because the format is mentioned, it's a very exhaustive affidavit of income, which if answered truthfully, should truly depict the financial status of the petitioner. I would propose, add to this another requirement, add to this a full disclosure of all the other pending litigations, inter-parties. Is there a 498A pending? Is there a 125 pending? Is there a DVAC case pending? Have you filed other cases? In one of the cases that I am party to, one of my clients is now the subject of not only these 4 cases, but also the subject of defamation and criminal theft of a national emblem. Because the party sent a letter on which had the Ashok Stamp on it, because the party is a southern government office. So now I have 6 cases that I have faced. But no single court that is dealing with this matter is aware of it. So they are relying on competent advocates to come and dig out this truth and place it before the court. Sir, in दोनों parties में तो बहुत litigation pending है, matrimonial है. But they don't know it. Add this column to that affidavit, give a complete picture to the judge deciding. Today the problem we face is your 498A case can go before one particular judge, your DVAC will go before a DVAC judge, your 125 will go before family, your divorce may go before a family. You could be fighting in 4 or 5 different fora. Sometimes on the very same day with 6 or 7 different advocates. Is this the result we want from matrimony, really speaking? I mean, considering that I started out saying that I am unmarried, I must worry for myself if this could be the potential outcome of a marriage at some stage. And therefore we seek this reform. But we seek balance in this reform. I am not one to say that men are the only persons who suffer. Not for a minute will I say that. I will in fact stipulate that women suffer far more. But litigation and the laws that lead to it today suffer from fundamental imbalance. And this imbalance needs to be corrected. Before I sign off, I just want to perhaps raise a red herring or some sort of segue here. The Uniform Civil Code today is a very hot topic. Whatever your personal beliefs may be, it is a very, very hot topic. Suggestions have been called by the government for determining the course of action. Now, I would propose that any uniform, for the record, I am for the Uniform Civil Code. I believe that everybody ought to be covered under one uniform law. We are all citizens of the same republic. We should all be bound by the same set of laws. Now, whether you agree or disagree with me, going forward, any statutory enactment, whether it is the Uniform Civil Code or otherwise, must redress both issues that are of systemic and institutional bias as well as fundamental human bias. Let me give you an example. The NAS Foundation case. The NAS Foundation case decriminalized homosexuality when it went to the High Court. When it went to the Supreme Court reversed that order. But everywhere in the world today, rights of homosexuals to get married is being recognized. If we are going forward tomorrow with a gender neutral, balanced piece of legislation that deals with all matrimonial issues, should we be leaving the homosexuals behind is another question that we need to ask. So my intention today was only to provoke some thought, to sow some seeds of thought and introspection within the audience and the esteemed members of the panel. And I hope that I have been able to do that. And with that, I will leave you, and thank you very much for having me here. It has been a pleasure and an honor and a privilege to talk with all of you and to be in the presence of all the esteemed guests. Thank you very much.